I'm honoured to be your speaker tonight. When I told my wife that I'd been asked to speak to such important and intelligent people, she asked me what I thought was unnecessary scepticism, why such educated people would want me to speak, and what was my topic. My reply was that I would give my usual humorous talk about interesting matters that occur from time to time in the Magistrates Court. She informed me that she did not find any of my stories very amusing, and that my talks generally consisted of stories which poked fun at the unfortunates that appeared before me. I assured her that this time I would not talk about the solicitors, but their clients. But she seemed to be still not satisfied. She argued that my tales of naked persons in general misbehaviour were beneath the dignity of the audience of distinguished people that are gathered here tonight. Obviously she didn't know that Jim Crockett was going to come, and John Thorne and a few others that I've noticed. Over 40 years of marriage, though, have taught me, even though I had my doubts, that and I wanted to resort to my normal off-the-cuff Christmas talks that I give to JPs and up, etc. 43 years of marriage have taught me to obey, if nothing else. My talk there tonight will therefore be nothing like I originally contemplated, but will be a brief overview of my 50 years of law in practice as a lawyer and a magistrate, touching upon 4 particular cases which attracted political and public interest at the time. I graduated with a degree in law from the University of Tasmania in 1974, with approximately 40 others, 5 of whom were women, and I was apprenticed to Albert Ogilvie, the father of Madeline Ogilvie, who is the nephew of the Premier of the same name, at the firm of Everett, Leavers, Hand and Ogilvie. After a gap year travelling overseas, I returned in 1977 and obtained employment, and soon after a partnership with a firm called Norma Leavers & Co. Norma Leavers was only the second woman law graduate from the University of Tasmania and was the first to practice in Tasmania. At that stage, I began employment with her. She was the only woman who was a partner at a legal firm in Tasmania. As an aside, I note that the number of women graduates now in law greatly exceed that of men. Approximately 60% of graduates now are women, and that women constitute the majority of the judges on the High Court. So there's been a lot of achievements in that regard, a lot of movement. In July 1979, there was a general election for the House of Assembly in Tasmania. The Labor Party under Doug Lowe, who had become Premier upon the retirement of Bill Nielsen in 1977, won a landslide, winning 20 seats to the Liberals' 15. There was much rejoicing in the ranks of the Labor supporters, but there was no joy in the home of William G. McKinnon. Bill McKinnon had been a Labor member for the seat of Franklin prior to the election, but had not been re-elected. He was upset. He consulted his solicitor, me. He was particularly upset that the Labor Party newcomer, Michael Aird, had been elected in his place, and attributed this to the fact that the Premier, Doug Lowe, had supported and pushed for Michael Aird to be elected. Bill, once I understood what he was saying because he spoke in a very broad Scottish accent, told me that he wanted to challenge the election result. Of course, an election result cannot be challenged simply because a member of the party falls out of favour with its leader. More promising, however, was the fact that it was likely that Michael Aird had breached Section 137 of the Electoral Act 1907, which stated, "No electoral expense shall be allowed in respect of any candidature in excess of $1,500 for each candidate." It was likely that Michael Aird had exceeded the expenditure because all candidates did. They did it willy-nilly without regard to their own legislation. They ignored the rules in relation to spending. And Michael Aird had run a particularly high-profile campaign. i.e. an expensive campaign. I warned Mr McKinnon that such an action might be futile, as I suspected the government might attempt to retrospectively change the law if we commenced proceedings. But if we pressed on. At that time, I was a partner with Philip Jackson, who's now a senior counsel. We were both, in his case, admitted for 1 year, in my case for 2 years, and we'd been principally involved in personal injury litigation. Imagine two young practitioners, barely out of law school, about to challenge the state election result. Me as a member of the Labor Party at the time, not a popular move. A petition was issued disputing the election results in the seat of Franklin. That's where Bill McKinnon missed out, of course. Michael Aird sought legal advice from my old master, Albert Ogilvie, and Albert advised Michael Aird to organise for all unsuccessful Labor candidates in Tasmania to issue similar petitions to seek to overturn the election results in their electorates. Now, the idea of Albert was obviously to convert what was a legal problem into a political dispute, because we hadn't culled it legally because we knew they'd overspent. So we couldn't lose, but he wanted to make the issue bigger than Ben-Hur, and therefore try to involve Parliament in changing legislation. Petitions were issued in all electorates, and the media went into a frenzy about the constitutional crisis and the need for another statewide election. At this time, the newspapers reported that the government and opposition were considering retrospectively changing legislation to validate the election result, which I knew they would. However, the Legislative Council made it clear that such legislation would be rejected by it. The dispute in Franklin was resolved shortly after the issue of the petition, when Eric Barnard, who had in fact been a government minister and had been re-elected, was advised that he was no longer to be in cabinet, and he declared his intention to retire, leaving a vacancy to be filled on a recount. I imagine that he said he decided to retire because he wanted to spend more time with his family, when in fact, of course, his pension was dependent on the number of years that you were a minister divided by the number of years you were in Parliament divided by whatever. So he's going to lose money if he can remain in Parliament, but I might be a cynic. Upon the resignation of Eric Barnard, we withdrew the petition, and Bill McKinnon was elected to fill the casual vacancy. From that time, we were no longer involved in that dispute. However, the petitions remained in the other electorates. Petitions were withdrawn in 2 electorates. This left petitions remaining in Denison and Bass. Ultimately, the matter came before His Honour, Justice Neville. The petition in Bass was dismissed as Mr Brooks, who was the petitioner in that electorate, failed to produce any evidence of overspending. I'm not sure whether a deal was done. Come in, Mr Crotty, I've already mentioned you.
Hello.
The petition in Bass was dismissed as Mr Brooks, who was the petitioner in that electorate, failed to produce any evidence of overspending. I imagine a deal was done behind the scenes, but in any event, that petition was dismissed, and the petition in Denison was successful. A new election was held in Denison in February 1980, and this was the first election in Tasmania to use the Robson rotational ballot. They took the opportunity of a by-election, which are rare in Tasmania, because we don't normally have a by-election, we just elect them on the recount, the new member. The aftermath of the petitions in the election were: the Electoral Act was amended to remove monetary limits on spending in the House of Assembly, but not the Legislative Council. Bob Baker, Liberal, and John Green, Labor, who had been successful candidates in the original election in Denison, lost their seats in the by-election. In the case of John Green, this was somewhat ironic because he had referred Bill McKinnon to me and suggested to Bill McKinnon that he challenge the election result. The 2 candidates who lost their seat in the by-election were replaced by Norm Sanders, so the For the first time, we had a third party in the state, and Gabriel Harris was elected as a Liberal, replacing Bob Baker. Just as an aside, 4 years later, Bill McKinnon missed out again on the election and came to see me because he missed out on his parliamentary pension by 2 days. I looked and looked and looked and I couldn't make 2 days up. So, in 1986, I decided to try for political office and stood as a Labor candidate for the Legislative Council seat at Newdigate, a seat which no longer exists. In summary, I heard the call of the people, I answered the phone, and it was a wrong number. However, I campaigned hard in the northern suburbs, but every second person I noticed said to me, "You're only standing for the money, you only want the money." I reported this to Jill. She said, "How much do politicians get paid?" looking very worried. I replied, "I don't know, but I assume it's reasonable, otherwise they wouldn't stand." After I'd made some inquiries, I found out that a member of the Legislative Council was getting paid exactly one half of what I was earning. And I told Jill. She said, "You better not get elected." That ended my political ambitions. By 1989, I was practising in my own firm of lawyers called CP Webster and Associates, principally as a civil lawyer. That means I was engaged in all types of litigation, except matrimonial or criminal. It does not mean that I was particularly polite, any more than the description criminal lawyer means that a lawyer is a criminal. Yes. As a civil lawyer, I was involved principally with personal injury claims arising from motor vehicle accidents, industrial accidents, or medical negligence. I acted for both injured parties and for insurance companies in equal measure. In that year, my firm amalgamated with Wallace, Mead and Wilkinson to become Wallace, Wilkinson and Webster. The alliteration was too attractive not to merge. In June 1991, Tasmanian TV broke a story that a political identity had been interviewed regarding potential corruption. Subsequently, many stories appeared in the media speculating about the reasons for a police investigation involving politicians. At this time, I was consulted by Mr. Michael Clark, the head of the Premier's Department, who the police wanted to interview regarding the circumstances of the appointment of Neil Batt to the position of Ombudsman. I went with him to the police interview, and despite the fact that he wanted to speak to the police, he acted upon my advice and exercised his right to make no statement to the police. No police action was ever taken against Mr. Clark. Mr. Clark is now deceased. I might say that it was the first time I'd been to a police interview, and it's very frightening. I would have admitted to the Whitechapel murders if I'd been asked. Unfortunately for Mr. Alan Evans, the head of the Premier's office, he'd been represented by another solicitor who was employed in a public service type position and been given him some free advice, and he made a statement to the police. On the 15th of July 1991, he was charged under section 111A of the Criminal Code Act 1924 with the crime of bargaining for public office. Mr. Alan Evans subsequently consulted me and asked me to act on his behalf, and I coordinated a large legal team which acted for him. John Cable, now deceased, was one of the counsel acting for Alan Evans. The Evans case related to the circumstances surrounding the appointment of Mr. Neil Batt to the position of Ombudsman on the 18th of August 1989. Mr. Batt had been re-elected to Parliament in 1985 and installed as Leader of the Opposition. During 1988, he was deposed as Leader by Mr. Michael Field and subsequently lost his seat in the May 1989 election. During discussions after the election with the Premier, Mr. Robin Gray, about his employment prospects, Mr. Batt was encouraged to apply for the position of Ombudsman and submitted a late application. Sounds a bit like that Deputy Premier in in New South Wales that applied for the position of to New York, doesn't it? He was one of the 2 applicants selected by the interview panel as being suitable. Before any appointment could be made, the government was defeated on the floor of the House of Assembly and the field Labor government was installed. Mr. Batt, perhaps not surprisingly, was appointed as Ombudsman. In June 1991, so several years after he'd been appointed and left the position, Mr. Batt spoke to the Secretary of the Department of Justice, Mr. Julian Green, and alleged that soon after the Labor government had been commissioned, Mr. Alan Evans, the head of the Premier's office, had approached him suggesting that the Ombudsman's position would be available to him in return for him agreeing not to contest a recount if a sitting member of Denison were to resign. So they didn't want, according to Mr. Batt, they didn't want him to come back into Parliament and threaten to become Premier again. Mr. Batt said he was required to sign an undated letter to the Chief Electoral Officer informing him that he had decided not to seek election or to be included in a recount. Mr. Green requested and received a copy of the letter and then referred the matter to the Director of Public Prosecutions, who was Mr. Bug at that stage, and Mr. Evans was charged with a charge to which I've already referred, i.e. bargaining for public office. At that time, a matter which was intended to be heard in the criminal court could only proceed to the criminal court if a magistrate found a prima facie case existed. So it was a 2-step process. You had to go to a magistrate, show that a prima facie case existed, and then the magistrate would commit you to the, if you found a prima facie case, to the criminal court. These proceedings were known as committals. The threshold for a committal was very low, so most times the prosecution didn't even have to call all their witnesses. They only had to call enough to show that there was an argument. Credit wasn't an issue, but it was very rare for a defendant not to be committed. Obviously, these procedures attracted a lot of press coverage, and the smell of corruption did not help the already unpopular field minority government. On the 16th of December 1991, the matter was heard by Magistrate Stephen Escort, now Justice Stephen Escort, and he delivered a decision on the 24th of December 1991, day before Christmas, declining to commit Alan Evans for trial in the criminal court, an early Christmas present for Mr. Evans. Now, most of the facts weren't in dispute, they were all basically agreed. But the magistrate gave 2 reasons for declining to commit. Namely, there was no evidence that Mr. Evans was acting wrongly or intended to so act. I'm not quite sure about that one, but this one's a stronger one. That Mr. Batt's agreement not to contest any recount did not confer any benefit on anyone in that his promise and letters were not legally binding. And that Mr. Batt could have changed his mind at any time and contested any by-election at that stage. So there was no bargain because he could renege from that bargain or that agreement at any time. It was illegal anyway to stop someone from, and against public interest, to stop someone from standing. The aftermath. Well, the DPP didn't take it too well. He didn't like the fact that the magistrate had refused to commit, so he abolished committals. So in Tasmania now, we have no power not to commit anyone charged with a criminal offence. We simply send them straight up to the criminal court. We have a different proceedings called preliminary proceedings. Committals still remain in every other state. So you often read about committals and magistrates refusing to commit someone or committing someone. In Tasmania, we just don't have that system anymore. At the 1992 state election that followed shortly after that case, the Labor Party's vote plummeted. The Labor Party won only 13 seats, the Greens 5, the Liberals 17, and Ray Green formed a minority government. By 2006, I decided I'd been in private practice long enough and I needed a change. I applied for the position of magistrate. On the 1st of March 2006, I was appointed magistrate. By virtue of my appointment as a magistrate, I was also a coroner. As a magistrate, my principal focus is dealing with crime. However, this work is interspersed with criminal and coronial work. All criminal cases are commenced in the Magistrates Court, and 98% of the 21,000 cases that start in the Magistrates Court are finalised in that court. I probably do about 3,000 cases a year. It sounds a lot, but when I realise that some of those cases are only pleas of mitigation for breathalyzers, you can do a lot of those in a morning. I think my record for pleas of mitigation in one morning is 30. I didn't let the lawyers say much, but magistrates sit every day in court, being scheduled only 2 days per month out of court so they can write decisions or deal with administrative work. Obviously, the Chief Magistrate has extra time out of court to deal with administrative matters. As a magistrate, I often feel like King Canute trying to stop the tide. On their way to the criminal court, I dealt with, by way of preliminary proceedings, which are what the committals are, formal committals have been replaced by, notorious cases such as Susan Neal-Fraser and Stephen Standage, a man who killed two people over 10 years apart because he owed them money in respect of drug dealings. Wasn't a good person to owe money to. Not for him to owe you money. Matters wholly dealt with in the Magistrates Court can be serious. Family violence, causing death or grievous bodily harm by negligent driving, assaults, sexual or otherwise, dishonesty, or maybe more run-of-the-mill such as breathalyzers, traffic offences, social offences, drunken, public, failing to obey the direction of the police officer, the usual dross that we get. But unlike judges in the criminal court who have delegated their decision-making powers to juries, magistrates have to look defendants in the eye and tell them why they've been found guilty. Magistrates also, unlike a jury, have to give reasons for acquittals or finding of guilt. On other occasions, an even more difficult task we have is to look the victim in the eye and tell them why we have not found the defendant guilty, why they haven't been believed when they allege that someone's, or why we haven't found the person who's alleged to have committed a sexual assault on them guilty, why we haven't been satisfied beyond reasonable doubt as to someone's guilt, or why the prosecution have messed up the case and been overcome by clever defence lawyers. But due to the seriousness of our work and sheer volume, humour should usually be avoided and is avoided, but on occasions it is impossible to avoid. In one matter, the defendant was charged with committing a public nuisance. We have fancy names for crimes, but public nuisance is basically charging someone for urinating in public. The facts as stated by the prosecutor were that the police car had driven around the corner and the two officers saw the defendant urinating over the double-decker bus. I inquired as to whether he was urinating on the double-decker bus or whether he was actually going for a world record by going over the double-decker bus. But was met with a response from the female prosecutor that she didn't know because she was only a girl. On the 22nd of September 2007, a large fire occurred at the premises at Myer Department Store at Liverpool Street, Hobart. Although a coroner is not obliged to conduct an inquest if there is no death involved, the Coroner's Act states that an investigation shall be held by a coroner if the Chief Magistrate or Attorney General so directs. The Chief Magistrate decided to conduct an inquest and nominated me to conduct that inquest. An inquest was held over 15 days in April and June 2009. I could not find a cause of the fire, but made a number of recommendations and criticisms of the Tasmanian Fire Service. The Fire Service had arrived before the fire had taken hold. At that stage, water was flowing from the overhead sprinklers and the electricity had not been turned off at the mains. The fire warden at Myers took the first fire officer who attended the fire to the fire board and indicated to that office officer the off switch, but the officer declined to turn off the off switch because, to use his words, which he used at the inquest, he was not going to take the advice of a woman's underwear salesperson. I wonder why we have all these fire drills and appoint fire wardens if no one's going to listen to them. The fire service turned off the sprinklers to prevent the risk of electrocution because they couldn't turn the power off. They couldn't turn the power off because they didn't know how to turn the power off after ignoring the advice of the underwear salesperson. It became apparent that the fire service were not trained to deal with multi-storey fires and had no experience in such fires at all. Later, when the fire became worse and they were using hoses inside the building, there was electrical arcing and the firefighters were ordered out of the building and to fight the fire from outside. Later, but alas too late, the fire service became aware that Aurora could turn the power off remotely. They only had to be asked. Once they found out, they rang up Aurora, and Aurora turned off the power to the whole block within 7 minutes after the request was made. The mistake made by the fire service was that of turning off the water when it should have turned off the electricity and allowed the sprinklers and hoses to do their work. The expert evidence was that the sprinkler system itself would have put the fire out. That was the expert evidence. They brought in experts from England, all around Australia. Experienced firefighters said you just leave that, and engineers said you just let the sprinkler system work and it puts out the fire. In fact, there was a textbook written by an H.W. Marriott called Fire, A Century of Automatic Sprinkler Protection in Australia and New Zealand, 1886 to 1986, which concludes that no building protected by a sprinkler system, properly installed and uncompromised, has ever been destroyed. So as long as your system's working okay, as long as the car hasn't run into your sprinkler system and put it out of action, the sprinkler system will put out the fire. Perhaps this fascinating book could be a late addition to your Christmas stockings. I was a little disturbed after my findings had been published to hear the Chief Fire Officer state in a TV interview that if there was another similar fire, the fire services would not do anything different. So if they did this and the building burnt down and they do the same again, I suspect the building might burn down again. On the 24th of March 2013, a young woman, Natalia Dawn Pern, was killed as a result of a head-on motor vehicle collision on the Midlands Highway. Mr. Tim Ellis, Senior Counsel, the Director of Public Prosecution, was the driver of the other vehicle and was charged with causing death by negligent driving. None of the Tasmanian magistrates wanted to hear the case. They thought they shouldn't hear the case. Obviously, some knew Mr. Ellis too well. Some were personal friends. One was his master. Some had worked with him when he was the Director of Public Prosecutions, had come from there. But we all thought that an independent magistrate from interstate would avoid the perception of bias, particularly in the event that Mr. Ellis was acquitted. Might be all right to find him guilty. You can't be criticised by the general public, but if you acquitted him, people would say, oh, he only got off because you're his mate, or words to that effect. The government, despite representations from the magistrates, refused to appoint an interstate magistrate to hear the case, though it appointed a Deputy Director of Public Prosecutions from New South Wales to prosecute the case. Mr. Ellis wanted a Tasmanian magistrate and to hear the case, and I don't know why he wanted a Tasmanian magistrate to hear the case, but he certainly didn't assist the magistrates when they were asking for an interstate magistrate to hear the matter. Unfortunately, I was allocated the case. Mr. Ellis' defence was that he was not negligent, as he had unexpectedly and suddenly fallen asleep whilst driving, and that therefore he was not driving at the time of the collision. Well, it sounds like a fancy defence, but when you look up the law, that's the law. It's clear if you fall asleep, you can't be driving at the time of the actual collision, and therefore you can't be negligently driving. This defence has to be disproved by the prosecution, and if it could not be disproved by the prosecution could not succeed. Ultimately, after a long hearing, I did not accept that Mr. Ellis had unexpectedly and suddenly fallen asleep. The main reason that I did not accept this evidence was that it was ample evidence that Mr. Ellis had control of his vehicle immediately leading up to the collision in overtaken vehicles and managed to drive around a long sweeping bend immediately before the point of collision, which required him to actually take control and steer the vehicle. These facts were inconsistent with him having fallen asleep and being unable to control his vehicle. On 25th of June 2014, I found the charges against Mr. Ellis proved. Not unexpectedly, Mr. Ellis appealed. His appeal was heard by a visiting judge from interstate who upheld the conviction. Mr. Ellis was subsequently sentenced by me, disqualified from driving, and received a suspended jail sentence. Shortly after he was sentenced, he resigned as Director of Public Prosecutions. Now, conscious of the time, conscious of your rumbling stomachs and your desire to start Christmas dinner, I'm reminded of Christmas and the past efforts of Hobart Magistrates Court to keep the traditions of Christmas alive around the world. David Killick, former Crime Editor of the Mercury, wrote this in the paper a few years ago. A defendant named Chris Kringle has been given an adjournment by Hobart Court because he is busy in December. Mr. Kringle appeared in the Hobart Magistrates Court this morning on a series of driving charges. His lawyer, Jessica Sawyer, applied for an adjournment. Mr. Kringle has some pressing engagements in December, she said. The comment left Deputy Chief Magistrate Michael Darley momentarily unable to respond and brought laughter from the public gallery. Due to Mr. Kringle's busy Christmas schedule, he's entitled to an adjournment, the magistrate replied. Mr. Kringle's case was adjourned to January. Perhaps we should adjourn for dinner. Merry Christmas.